But it's only for the benefit of Justice Narasimha and Justice Sanjay Kumar, who were not there on the previous occasion. Just a few lines of introduction and then I get straight into the matter. This, Milords, is a regular criminal appeal arising out of a judgment of the Jharkhand High Court declining to quash prosecution against the appellant, who is being prosecuted under relevant provisions of the Prevention of Corruption Act and the Indian Penal Code for the alleged offense of taking a bribe to vote in a Rajya Sabha election. The appellant was at the relevant time a sitting MLA of Jharkhand. She's alleged to have taken a bribe from an independent candidate to vote for him rather than for her party candidate. But in the event, the vote was actually for her party candidate because that comes out in the open voting. Then there were complaints that election was countermanded. There was a fresh election. And again, she voted for her party candidate, etc. But she was sought to be prosecuted on this allegation. That is how, Milords, the matter arises. Your Lordships are, of course, not concerned with the merits of the appeal just now. I have, in my written submission, Milords, Volume 1, just touched upon the merits only to indicate the nature of the controversy. And we contend, Milords, that we have a strong case on merits. The order granting bail in 2014 passes adverse observations against the CBI, Milords, and the CBI has not appealed against the order granting bail. So apart from other things, Milords, apart from immunity, I have a strong case on merits, but of course, your Lordships are not concerned with that, Milords. Now, Milords, can I first place the language of the articles, then come to the order of reference, and then come straight to my submissions, Milords. Constitution direction. All my lords have got 105. 1. Subject to the provisions of this Constitution and to the rules and standing orders regulating the procedure of Parliament, there shall be freedom of speech in Parliament. So that is, Milords, subject to the provisions of the Constitution. But, Milords, 105(2), no member of Parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him in Parliament. Kindly note here the word Parliament, because I'm going to draw a distinction with the second part, Milords, of this provision, or any committee thereof, and no person shall be so liable in respect to the publication by or under the authority of either House of Parliament of any report, paper, votes, or proceedings. So the same clause, Milords, of Article 105(2) uses Parliament in two different contexts, Milords. One, Parliament, the other is House of Parliament, and I am going to make a submission on that, Milords, in due course. 3. In other respects, the powers, privileges, and immunities of each House of Parliament and of the members and the committees of each House shall be such as may from time to time be defined by Parliament by law, and until so defined shall be those of that House and its members and committees immediately before the coming into force of Section 15 of the Constitution, 44th Amendment Act, 1978. The provisions of clauses 1, 2, and 3 shall apply in relation to persons by virtue of this Constitution, who by virtue of this Constitution have the right to speak in and otherwise take part in the proceedings of a House of Parliament or any committee thereof as they apply in relation to members of Parliament. Therefore, my learned friend, the Attorney General, addresses Parliament, Milords, he will also have the same immunity. Now, Milords, may I take my lords straight to the order of reference dated 20th of September. It is, Milords, a detailed order of 16 pages. But for the present purpose, Milords, it's enough for me, Milords. This will be at page 3 of volume 3. I'll take my lord straight to para 24 at page 15. If all my lords have got minutes. My lord Chief Justice, we are inclined to agree with the submission of the amicus curiae and Mr. Gopal Shankar Narayanan, Senior Counsel, that the view which has been expressed in the decision of the majority in PV Narasimha Rao requires to be reconsidered by a larger bench. Our reasons prima facie for doing so are formulated below. 1. Firstly, the interpretation of Article 105(2) and the corresponding provisions of 194(2) of the Constitution must be guided by the text, context, and the object and purpose underlying the provision. The fundamental purpose and object underlying Article 105(2) of the Constitution is that members of Parliament, or as the case may be, of the state legislatures, must be free to express their views on the floor of the House or to cast their votes either in the House or as members of the committees of the House without fear of consequences. While Article 19(1)(a) of the Constitution recognizes the individual right to the freedom of speech and expression, Article 105(2) institutionalizes that right by recognizing the importance of the members of the legislature having the freedom to express themselves and to cast their ballots without fear of reprisal or consequences. In other words, the object of Article 105(2) and or Article 194(2) does not prima facie appear to be to render immunity from the launch of criminal proceedings for a violation of the criminal law which may arise independently of the exercise of the rights and duties as a member of Parliament or of the legislature of a state. Secondly, in the course of the judgment in PV Narasimha Rao, Justice S.C. Agarwal noted a serious anomaly. If the construction in support of immunity under Article 105(2) for a bribe taker were to be accepted, a member would enjoy immunity from prosecution for such a charge if the member accepts the bribe for speaking or giving their vote in Parliament in a particular manner and in fact speaks or gives a vote in Parliament in that manner. On the other hand, no immunity would attach and the member of the legislature would be liable to be prosecuted on a charge of bribery if they accept the bribe for not speaking or for not giving their vote on a matter under consideration before the House, but they act to the contrary. This anomaly, just as Agarwal observed, would be avoided if the words in respect of in Article 105(2) are construed to mean arising out of. I'm going to contest that, Bruce. In other words, in such a case, the immunity would be available only if the speech that has been made or the vote that has been given is an essential or integral part for the cause of action for the proceedings giving rise to the law. And thirdly, the judgment of Justice S.C. Agarwal has specifically dwelt on the question as to when the offense of bribery would be complete. The judgment notes that the offense is complete with the acceptance of the money or on the agreement to accept the money being concluded and is not dependent on the performance of the illegal promise by the receiver. The receiver of the bribe would be treated to have committed the offense even when he fails to perform the bargain underlying the tender and acceptance of the bribe. This aspect bearing on the constituent elements of the offense of bribe finds elaboration in the judgment of Justice Agarwal, but is not dealt with in the judgment of the majority. I'm going to submit minutes that the fact that the majority did not specifically say when the offense of bribery is complete does not make a difference to the correctness of that conclusion, because the majority could not have thought otherwise. The offense of bribery was, after all, in criminal law complete earlier. But that, in my respectful submission, would not have a bearing on the question.